Right, this is the second of the two introductory lectures to JR, and this is what I'm going to be covering in this lecture. The main source of interest will be the idea of standing. I'm going to be looking at the general rules on standing, i.e. who can apply for a judicial review, but looking also at a number of cases in relation to pressure or interest groups. Towards the end, we're also going to be looking at things called ouster clauses and a subset of ouster clauses known as limitation clauses. And right at the end, I'm just going to be dealing fairly briefly with the type of remedies that it's possible to get under the judicial review process. So let's start with the main topic today of standing, or to give it a bit of a Latin flavour, locus standi as it's sometimes called in some of the older cases. And this means who can make a claim using the JR procedure. And the key test for this comes from the old Senior Courts Act, it used to be called the Supreme Courts Act of 1981, and the key section is section 31.3. So you all need this as an authority in problem questions, and the test has effectively been kept the same under the newer Civil Procedure Rules Part 54. So the test from section 31.3 is that the court shall not grant leave, nowadays that's called permission, unless it considers that the applicant has, these are the key words, sufficient interest in the matter to which the application relates. So sufficient interest is the key established test in this area. Now, the majority of judicial review applications do not present any particular problem when it comes to establishing standing. An individual or an organisation, effectively anyone with legal personality, which has a direct individual interest in the matter which they're trying to challenge, will have no problem at all convincing the court of their status in this respect. Problems or difficulties arise when the connection between the challenger and the decision they wish to challenge is rather less clear-cut or less immediate, shall we say. And this tends to become an issue when the challenging body is an association of interested parties, or particularly a pressure group of some kind or other. And we need to develop an impression of this area of law by looking at some of the key cases. First case up today is the most sort of basic authority in this area. This is a case called the Fleet Street Casuals. Now, that's the nickname for the case, which you're perfectly able to use in exams. But the longer name of the case, as you can see up the top here, is the Inland Revenue Commissioners and the National Federation of Self-Employed and Small Businesses. And the National Federation were effectively a group of taxpayers. They wanted to challenge an arrangement, really, rather than a decision, an arrangement made by the Revenue, the IRC. And essentially, what the Revenue had decided was that it would grant a kind of amnesty for a group of casual workers in some of the Fleet Street newspapers who had what would probably charitably be called a flexible attitude towards paying their taxes. Now, the Federation members were far from happy about this favourable treatment for the Fleet Street casuals. They saw it as double standards being operated. So, the National Federation here was complaining about arrangements made by the Revenue relating to other people's taxes. That's the point. This issue, therefore only affected them in an indirect sense, i.e. the amnesty was given to others. This seemed unfairly generous in comparison to their own taxation treatment. So, could therefore the Federation legitimately apply for an order from the court that the Inland Revenue's policy with regard to these casual employees was unlawful. That was the question, really. Now, on the wider substantive merits of the case, Lord Scarman and a number of other law lords was not ultimately persuaded that the Federation did have reasonable grounds for showing that there had been a failure in the revenue statutory duty. Nevertheless, had the Federation had a stronger case on the merits, Scarman said that he would have accepted that the Federation should be given standing to challenge this policy, this arrangement. This was in spite of their, at best, I suppose you could call it, indirect connection to the issue. Now, significantly here, Scarman emphasised, above all, the need for what he called, I quote, a generous conception of locus standi. In doing so, he rejected some earlier decisions which appeared to be much more restrictive, to suggest that standing was only appropriate for those who had a specific legal right to challenge the relevant decision. His view was that this older approach was far too restrictive and would have greatly reduced the effectiveness of the various public law remedies available. So in other words, what we have here is the genesis of really quite a liberal policy on standing. Now, this is very much backed up by what Lord Diplock was saying in the same case, the same Fleet Street Casuals case. I'm just going to read this for you here. He said that it will be a grave lacuna in our system of public law if a pressure group or even a single public-spirited taxpayer were prevented by outdated technical rules of locus standi from bringing the matter to the attention of the court to vindicate the rule of law and get the action lawfully stopped. Note in particular here the reference to vindication of the rule of law. This is a classic theme that the judges return to. Obviously further ammunition too for you in any essay you might write about the rule of law in the constitutional part of the exam. Remember, of course, what I said last time about judicial review being in many respects the practical manifestation of many of the key rule of law principles and values. Notably, of course, the need for public or executive power to be properly restrained. So, let's think about how the broader discussion in Fleet Street Casuals impacted on JR cases generally. In terms, I mean here, of the process or the procedure that has to be carried out. Now, the last time, or in the last lecture rather, I briefly mentioned that there are essentially two stages to the process. There's a preliminary hearing and then a main or substantive hearing. Now, after the Fleet Street Casuals case, the pattern has largely emerged where the court will look at standing at the preliminary stage. And effectively, applicants will be weeded out at this first permission stage if they clearly don't have sufficient interest or if the case is weak in a number of other respects. Remember that this sort of filtering stage is designed to be one of the key safeguards set up in the JR procedure to protect the general public interest in efficient public administration. Clearly, efficiency in government won't be aided if the more sort of eccentric members of society were constantly allowed to challenge and delay public decisions. Now, in some of the case law, they are described sort of in fairly derogatory terms as busybodies, cranks, mischief makers, etc. Now, of course, in reality, they're not all necessarily mad, but clearly there are going to be cases where the degree of interest of a particular challenger is not going to be considered sufficient. Another point we can take from Fleet Street Casual, so following on from this, is that the court may consider the issue of standing again at the main hearing. It doesn't just operate as a sort of filter mechanism. And they can look at it again later on, if necessary, together with the substantive merits of the challenge. Now, Lord Scarman called this, slightly cryptically I think, a mixed question of fact and law. This means it's not just purely a procedural question. And I think this is because, really, the wording of the 1981 Act said that the applicant should have sufficient interest in the matter to which the application relates. And because of that, it's necessary, of course, for the court to consider the matter. It's necessary to consider the factual side of things too, as well as the degree of proximity towards it, to it rather. In other words, this involves thinking about the merits of the case at the same time as the status of the party making the application. And these two issues, the fact and law, are inextricably linked. So, having set things up in that way, let's see how this generally liberal approach to standing that was advocated by sort of important law lords like Diplock and Scarman and Fleet Street Casuals has worked its way through the case law. Now, this is just a rough diagram. It's not supposed to be some scientific exercise, but I think you can divide the types of challenges into four broad groups. So, in the top left-hand corner, this really is the most obvious group. Those individual legal persons, either people or companies, whose interests are immediately impacted or directly affected. Remember that the latter was the phrase we used in Human Rights Act law, where standing is generally much more restrictive than it is in JR. Clearly, in judicial review, the issue of standing is a wider concept because, as you can see from this diagram, standing can also be given to associations or collectives of those who have been directly affected, top right-hand corner, but also, most notably, we do have numerous examples in this bottom part of this page of standing given either, on the left-hand side, to individual citizens, what are sometimes called concerned citizens, or to interest or pressure groups whose own immediate interests aren't directly affected, but who may nevertheless be allowed to challenge public law decisions in certain situations. So let's consider the sort of categories 2, 3, and 4. Let's do this one, the top right-hand corner one here, the associations. Let's look at that firstly. Now here, it's long been accepted that associations of individuals can represent their members at court if those individual members are directly impacted or affected by the decision that is being challenged. And I think this makes a lot of sense. After all, it's considerably more efficient and cost-effective for there to be one applicant, the association, rather than lots and lots of individual claimants who may be the members of the association. So, for instance, a good example of this is a case from 1972 involving an association of taxi drivers in Liverpool, the Taxi Fleet Operators Association. This association was allowed standing as a group to challenge the decision of Liverpool Council to change regulation of its taxi licences. And we'll see this case a little bit further along in the course. Another similar-ish example, not quite the same thing, but similar, is the case involving the Equal Opportunities Commission. That's what EOC stands for. Now, the EOC, which is effectively a quango, isn't an association as such, but was effectively operating as a representative for all those directly impacted by a particular decision of the Employment Secretary. The claim was that certain statutory provisions relating to employment rights were inconsistent with EC law because they were effectively discriminatory to female employees. Now here, the court was happy to grant standing to the Commission as a representative body of potentially thousands of women who were affected by the inconsistency in the law. So, in other words, the principle has been very well established that such larger groups can apply to the court on behalf of individual members. The next question, though, is to what extent can parties without such a direct question to the specific decision or action that they are challenging, to what extent will they be allowed to make an application for judicial review? Now, going back to my sort of four-part diagram, we're talking here about the bottom left-hand corner, the so-called concerned citizens. Let's think about those firstly. So who we're considering here are what are sometimes called, possibly slightly patronisingly, who knows, public-spirited individuals who want to challenge public law decisions based not so much on their individual link to the issue concerned, for instance, any sort of direct financial or property interest, but because of the nature of the issue itself, which they are concerned about. Now, the first of these cases on this slide relates to our old acquaintance, Mary Whitehouse, who was allowed to challenge a decision of the IBA, that's the Independent Broadcasting Authority, effectively ITV, to broadcast a film, which as you can see here was called Scum, on mainline telly, on ITV. Now, as you can imagine from the title, this wasn't really Mrs. Whitehouse's thing, and it involved all sorts of terribly bad language and violence and such like. It was basically about the Borstal system. And as you can see from this, I think this is the front cover of the video, it featured a very young Ray Winston in the film. It's quite an interesting film, actually. So, Mary Whitehouse, as a concerned citizen, was given the right to challenge the legality of that decision to show this TV programme, film, at a certain time. She was given standing. Another example, the middle example, involved a local journalist called Lee, who was intent on challenging a policy of the Magistrates' Court in Felixstowe, Suffolk, which was to withhold the names of JPs, Justices of the Peace, in other words, magistrates, during the hearing of cases themselves. The court, the admin court, decided, they gave Mr. Lee standing to challenge this, and decided actually that principles of open justice did require the identity of magistrates to be known. And of course they accepted Mr. Lee's right to challenge this unusual situation and to apply for a declaration that this policy was unlawful, which is what he did successfully. And this, of course, was because this was seen to be a matter of significant public concern about the administration of justice. And Mr. Lee was able to show sufficient interest in that as a cause of concern. Last example on this page involves this man here, William Rees-Mogg, who was the former editor of The Times and father of current MP Jacob Rees-Mogg. He was given standing to challenge the government of the day over the legality of the Maastricht Treaty because of what the court called his very clear interest in EU issues generally. I think that's rather unstating things, but the court called this his, quote, sincere concern for constitutional matters. They were reassured that this was a real and continued concern, as illustrated by a lot of his writing in the Times. Now, of course, the issue about the legality of the Maastricht Treaty is a rather sort of high-level national issue. His interest was very much an ideological one in being basically anti-EU, rather than one inspired by any direct personal contacts or connections he had with the issue. But nevertheless, he was given standing to challenge this, which you won't be surprised to hear was unsuccessful. In such situations, I think we can say that the courts have increasingly come round to the idea that it is important, really, as an exercise in itself, for such decisions to be reviewable. And we'll see this reflected further in the next sort of group of cases I want to look at. These are the ones that bring in bigger pressure groups as challenges. So, let's firstly go back to remember the generally really quite flexible liberal attitude taken by the law lords in the Fleet Street Casuals case in the early 1980s. Judges like Scarman and Diplock clearly thought that what they called a generous attitude should be taken towards standing. There is one slight sort of fly in the ointment here, though. One case that did for a while seem to buck this prevailing trend, and this is this case called Ex parte Rose Theatre Trust. Now, this involved an attempt by a group of interested parties to campaign for the protection of the remains, sort of the archaeological remains, of an old theatre on the South Bank in London, which had been uncovered, I think, partially by various development works in Southwark. Now, this theatre had apparently held plays by Marlowe and Shakespeare. It was clearly considered to be a site of potentially very significant national heritage interest. However, the court, the admin court here, did not ultimately agree that this trust had sufficient interest in order to grant it standing to challenge the decision made by the Secretary of State for the Environment. The judge, who was called Mr. Justice Sheeman, justified this decision largely on the basis that the trust had been set up. It had been inaugurated specifically to campaign about this newly discovered site. It hadn't in any way been an established, pre-existing local body. Okay. Sheeman on the right here is saying it would be absurd if two people, neither of whom had standing, could incorporate themselves into a company which thereby obtained standing. So he's saying effectively that this grouping of individuals who in their own right wouldn't have had sufficient connection to the issue couldn't simply sort of get round the rules, so to speak, by incorporating themselves as a purported interest group and thereby being able to challenge the matter through the JR courts. Key, I think, to his decision was the fact that this association did not comprise, apparently, any sort of locally directly affected people. Now, I think it's probably fair to say that in the long run of cases, this is a bit of an aberration, not necessarily because the judge's views were wrong as such, but because this does very much clash with the prevailing policy direction that has taken root since the early 80s and which soon revived itself shortly after the Rose Theatre Trust case. Okay. It's useful as a sort of mooting point in problem questions. You know, this idea that standing is being engineered by the creation of a newly established body. You know, it's a useful sort of mooting point. Anyway, 4 years or so after the somewhat harsh decision, one might say, in the Rose Theatre Trust case, this prevailing trend that I was talking about sort of reasserted itself, and this was in this Greenpeace No. 2 case. Now, this concerned the legality of a decision by this Inspectorate of Pollution here to allow British National Fuels Limited, so the sort of nuclear industry, to discharge waste from the Sellafield nuclear reprocessing plant up in Cumbria, essentially discharging waste into the Irish Sea, which has been a distinctly controversial practice over the years. Now, in this case, Greenpeace was allowed, as an organisation, to have standing to challenge the Inspectorate's decision. The judge, who was Mr. Justice Otten, clearly still remained conscious of the need to have some kind of restrictions on who can actually apply for judicial review. However, he was ultimately persuaded to give standing by a number of positive arguments in favour of Greenpeace. So firstly, they put quite a bit of store on the reputation of Greenpeace as an organisation, that's both nationally and internationally. This clearly added weight and conviction to its cause. Greenpeace was also seen to have considerable expertise in this particular area of sort of nuclear and environmental policy. In other words, they were an informed, responsible pressure group. They weren't some sort of noisy lobbying group. And reinforcing this quite positive impression of Greenpeace was the group's regional presence as an organisation. Not only did Greenpeace have a very sizable national membership in the UK, 400,000 or so, but also it had a sizable membership in the more specific area around Sellafield in Cumbria of around 2,500 members as well. So these members clearly did have more of a direct personal interest in their immediate environment. And therefore, I think often he is sort of reassuring himself by distinguishing this case on the sort of narrower ground from the Rose Theatre Trust a few years before. Again, underlying Otton's decision on standing was a clear view of the importance of this type of governmental decisions being challengeable in principle in the courts. And this approach, which one can find echoes of from Fleet Street Casuals several years before, was developed perhaps another stage further in the next case, which involves a further pressure group, this time called the World Development Movement. So this is the next case I want to have a look at. This case involved the funding, or partial funding, of a large hydroelectric project on the Pergau River in Malaysia, funding by the British Foreign Office. Now, the World Development Movement is a campaigning pressure group involved in giving advice, assistance, etc. on various international aid and development issues. They were a well-known group and they were respected. They had links, for instance, to UNESCO. And the World Development Movement wished to challenge the legality of the Foreign Office decision to give upwards of £230 million, quite a lot back then, well, still is really, of overseas aid money to this hydroelectric project. The apparent problem with that case was that clearly none of their members in the UK were likely to be directly impacted in any way at all by a project to set up a hydroelectric power station in the middle of the Malaysian jungle. Clearly their concern was general, and you might well say semi-political in nature. There were an awful lot of concerns, which you'll see reflected in some of these posters here, that this was really an almighty waste of development money, which might have been spent rather better, and which of course might have led to rather serious environmental impact in Malaysia too. Slightly more controversially, there were also rumours and suggestions at the time of sort of favours in return, possible corruption, exchange of arms deals and such like in exchange for all this nice development money. The court's view, which this is Court of Appeal, expressed by Lord Justice Rose, was that it was really important in principle that the legality of such an important governmental decision to spend all this money should be challengeable in the courts. Clearly, the court was conscious that the membership of the World Development Movement was not directly affected in the same way as, let's say, the Liverpool taxi drivers or the Cumbrian members of Greenpeace. But it was important for what the judge described as vindicating the rule of law for the world development movement to be able to challenge this decision in the absence of any other more closely affected or likely interested party. Okay, so this idea of vindication of the rule of law, which goes way back to Fleet Street Casuals, what I was mentioning with regard to Scarman and Diplock, is very much reasserting itself in cases like this. Okay, let's look at a few other examples of standing just to illustrate what I think we can say is a fairly liberal modern approach to this particular issue. Two cases on this slide. The first is quite an interesting one, the facts and what actually happened. I mentioned this briefly in passing before in a rule of law lecture. Here we have a campaigning group on sort of environmental and social issues called Corner House Research. And they were actually joined in the challenge by, I think, what we could probably call a rather more sort of overt semi-political lobbying group, namely the Campaign Against the Arms Trade. So, two challengers, challenging a decision by the director of the Serious Fraud Office. Now, this decision by the director was to drop long-running investigations into bribery allegations. It had been alleged that various arms contracts between the UK and Saudi Arabia, these were the famous Al-Yamama deals that were negotiated by Mrs. Thatcher and Michael Heseltine when he was Secretary of State for Defence in the 1980s. You'll see his picture here. Allegations that these had been, let's say, sweetened by various sort of bribes and slush funds and such like involving some of the Saudi royal family. So it's potentially a very sensitive investigation. Now, this quite clearly did not please the Saudi regime, and it was alleged that they had put quite considerable political pressure on the British government to get this inquiry dropped. They had basically made it known to Jonathan Powell, who was Tony Blair's Chief of Staff, that this would be a very good idea. And then it was alleged the government, in response to this sort of cloaked threat, had put pressure on the Serious Fraud Office to drop the investigation, and that's what happened. Now, in terms of standing, the court here felt that it was very important, again in principle, that government was challenged about really important matters of public administration. The court said that it was entirely legitimate to let these type of lobbying groups challenge these kinds of decisions. And on the facts, on the merits, the High Court was actually highly critical about how the government had appeared to cave into pressure from the Saudis. And the case was initially successful on the basis that effectively it had amounted to a sort of fairly blatant infringement of rule of law processes. In other words, political calculation, threats had supplanted the place of proper legal rules and process, inquiries and such like. This was really quite a bold judgment at its time, but it was later watered down and effectively reversed by the law lords. The other case is really an example of an interested or a concerned citizen, again, challenging a decision. And again, I think it shows the modern attitudes of the judiciary. This was actually about a dispute over a Scottish road planning issue. And it led the Supreme Court to reiterate some of these basic sort of constitutional standards. You'll see here that Lord Reid talks about the constitutional function of maintaining the rule of law. And it was necessary to allow sort of public-spirited people like Mr. Walton to challenge these types of decisions. Lord Hope, I explained the picture, this is an osprey by the way, Lord Hope waxed very lyrical about all this kind of thing because he got onto the hypothetical interests of ospreys. He basically asked who would look after the osprey's interests if there was a need to challenge a decision to, let's say, build a wind farm across the Osprey's route to its favourite fishing lock. Lord Hope said, I quote, if its interests are to be protected, the Ospreys that is, someone has to be allowed to speak up on his behalf. So this is the sort of general theory underlying this liberal approach to standing. Just lastly, one final example of how judicial review cases can sometimes involve large groupings of linked interest groups. A whole sort of panoply of groups comes together to challenge a particular decision. And this happened in the more recent case of HS2 Alliance, Action Alliance, it's called. Now, this is a case which has got constitutional lawyers quite excited. Obviously, it doesn't take a great deal, because it involves discussion about the status of the European Communities Act of 1972 as a so-called constitutional act. And it also is about how Parliament debates and scrutinises legislation. For our purposes today, though, I just really wanted to show you how a kind of umbrella, not-for-profit organisation can mount a judicial review challenge to a matter of significant national importance, i.e. the high-speed rail line planned from London to the north. Now, in this case, the HS2 Action Alliance worked with over 90 affiliated groups and residents' associations, and it was given standing to take its challenge all the way up to the Supreme Court. At the Supreme Court level, there were a number of other challenges as well. It was a sort of joined appeal. The Action Alliance case was heard alongside very similar challenges from a body called Heathrow Hub Limited, which was a company which has been promoting the idea of this sort of central massive transport hub based at Heathrow, i.e. that was a commercial challenger. But also, in addition to the Alliance and this commercial challenger, there was a challenge too, at the same time, from effectively local government. This came from the London Borough of Hillingdon and a group that was known as the 51M Group. This is a collection of 19 local authorities spread out along the proposed HS2 route north from London. So a whole sort of umbrella group of interests coming into play there. One brief proviso to the general impression I've given so far of really quite a liberal attitude to standing in the modern day and age. This applies when there is quite clearly a better or a more appropriate challenger to a particular decision. And this is quite well illustrated by this next case, which related to an attempt by the father of Jamie Bulger to challenge the tariff sentence imposed on the two boys who murdered his son. Okay. Obviously, Mr. Bulger, Ralph Bulger, did not think this was high enough. Now here, in the criminal law context, the court was obliged to find that Mr. Bulger could not be given standing to challenge the decision. And this was because the established position, based of course on the need for impartiality in sentencing, has always been that the relevant challengers must be the parties actually involved in the criminal process. So on the one side, that's the Crown, the prosecution, and on the other side, it's the defendants themselves, i.e. the people convicted. The victim of the crime, or their family in this case, is not a party to criminal proceedings. Therefore, Mr. Bulger, father of the victim, was not able to challenge the length of the sentences. So, I spent quite a lot of time on standing. The other major issue need to consider now, the next issue, is this notion of an ouster clause. So what we're considering here is whether it's ever going to be possible for a statutory provision, i.e. part of an act, to restrict or to remove entirely the remedy of judicial review from the courts. In other words, is it possible for there to be a sort of exclusion clause preventing the courts questioning or listening to the questioning of the legality of action taken under a particular statute? So if a statute imposes a statutory duty, but then also says the way in which this statutory duty is exercised shall not be a matter for the courts, will that clause apply or not? In admin law, these clauses are generally known as ouster clauses. They are attempts to oust the jurisdiction of the courts, in other words. Now, this tactic has quite a long history, and at certain stages of the 20th century, it's probably fair to say that prevailing political opinion did not object to ouster clauses. The idea really was that because we, of course, vote for Parliament and policy is enshrined in legislation, this should be enforced by the courts. It shouldn't be questioned and undermined by the courts. Now, I think this is really quite a sort of statist form of viewpoint. And it was probably particularly prevalent in the period from roughly the 1940s up until probably the late 1960s, during which time, arguably, there was a sort of wider political consensus that the general interest should outweigh the individual interest. However, I think partly as a reflection of a sort of developing more individualistic climate legally, the law lords came to a really very important decision, actually at the end of 1968, reported in 1969, that considerably restricted the ability of government through Parliament to oust judicial review of public decisions. And this is the very well-known Annes-Minnick case. Now, the background to this case was effectively the Suez Crisis of 1956. This man here is Colonel Nasser, ruler of Egypt at the time. Now, the Annes-Minnick Company owned various mining interests in the Sinai Peninsula in Egypt. And these, along with lots of other assets, international assets, were seized by Nasser's government in the mid-50s. This was part of an overall policy of nationalisation pushed through by Nasser, who's a very sort of dynamic political figure. Now, subsequently, Annes-Minnick claimed that it was eligible for compensation because of this seizure of its assets under a scheme that was set up by UK legislation. This was the Foreign Compensation Act of 1950. Now, this compensation was determined by a tribunal called, not surprisingly, the Foreign Compensation Commission. And this tribunal decided that Annes-Minnick, for various reasons, was not eligible. And so the company later attempted to challenge the legality of the Commission's decision. The apparent difficulty they faced in doing so was whether the admin court, had any jurisdiction at all to intervene in the tribunal's decision. And this was because Section 4.4 of the 1950 Act said the following. So see the box down here on the bottom left-hand corner. It said, Section 4.4, the determination by the Commission of an application, i.e. compensation, shall not be called into question by any court of law. This appeared, on the face of it, to oust the court's jurisdiction. It's sort of JR right, if you like. Nevertheless, on a 3-2 majority, the law lords said no, this clause was not effective. It decided that Section 4.4 did not prevent the court from reviewing whether or not the decision made by the Commission was lawful. And the majority, led by Lord Reid, said effectively that it would be really a gross affront to the rule of law if the court's powers of review were ousted, as this act appeared to suggest. If the court was not able to review the Commission's powers would really be legally unrestricted. And then, of course, it could go off and behave in a totally arbitrary way. Effectively, what you have here is the law lords interpreting their way around the apparently clear wording of the Act. And they did this by saying that, yes, we accept that a lawful determination by the Commission of any application could not be reviewed. But, guess what? If the determination was not lawful, the court could review it. And in fact, Lord Reid then went on to say that an unlawful determination was, quotes, in fact, no determination at all. All right? So, quite clever stuff here by the courts in order to extricate themselves from the grip of this ouster clause. So what we can conclude from that really is that the courts are very reluctant indeed to give effect to any legislation that seems to oust their jurisdiction in judicial review. Even when an exclusion is quite clearly worded, as arguably it was in Annus Minnig, the courts will not allow an ouster to apply if they can find any room at all for manoeuvre around it. So the wording of a clause would have to be exceptionally expressly clear. As you can probably appreciate, this is a really important constitutional case as well. It shows that the courts have used very purposive forms of statutory interpretation for really quite a long time when they felt the need to do so. Annus Minnig was decided, nearly 50 years ago now. So the courts have been intent on maintaining their function as guardians of the rule of law for really quite a long time. Just give you one more sort of example of a case involving a purported ouster clause. Again, here the ouster clause was effectively disregarded by the courts. This came in the Al-Fayed case, where Mohammed Al-Fayed was seeking a review of the decision to deny him a UK passport. Now, the relevant act here was the British Nationality Act of 1981. And I'll just read you the crucial extract from that. It said that the decision of the Home Secretary shall not be subject to appeal or review in any court of law. Again, even though this appears quite clear-cut, the court took a very similar view as in Annus Minnig. In other words, the court couldn't review a lawful decision, but it could review an unlawful one. So the court determines whether it's unlawful and then works backwards, in other words. Just one side point really here. Government attempts to make ouster clauses watertight, if you like, will also very much be subject to a considerable degree of political and sort of extrajudicial disapproval as well. Classic case, 11 years ago, the then Home Secretary, David Blunkett, tried to impose an ouster clause when steering this bill, the Asylum and Immigration Bill, through Parliament. This came up against an incredible amount of hostility, and he was obliged to withdraw the clause. This was generally seen to be, again, an assault on the rule of law, preventing the courts doing their proper job. And Lord Wolfe, who was then Lord Chief Justice, was particularly vocal at the time against the clause in this particular bill. Last point I want to make here is a bit more of a practical point. This is that if an exemption of judicial review jurisdiction is only really a partial one, a little bit like a limitation clause in contract law rather than an outright exclusion clause, then in this situation the courts will be less hostile in their approach. They will not be as strict in interpreting the clause. So here, for instance, in this East Ello case from the 50s, there wasn't an outright ouster, but there was a heavier, a more severe time restriction imposed on when you could issue judicial review proceedings. It was reduced from the standard sort of 3 months maximum to only 6 weeks for a particular compulsory purchase order. This limitation was accepted by the court because, of course, the implications are less serious. Right, that covers most things, but I do just want to have a couple of words about remedies. You don't need to consider this in massive detail in a problem question, but you should round off your question by covering very briefly what remedy you would suggest. As you can see here, remedies in JR are discretionary. Now, fortunately, since the Wolf reforms and the CPR in the late 90s, we are spared, on this course, the rather confusing old Latin names for what used to be called the prerogative orders. So you may well see in some of the older case law, old Latin names like certiorari and mandamus and such like being bandied around by the judges. These have been replaced and they now have rather more functional, although perhaps less interesting, names. Essentially, we have 3 main orders that are specific to JR. These are the top 3 here on this slide. Firstly, there's a quashing order, and this is really as it sounds, where the admin court either quashes a decision that has been made by a governmental body, or it can also quash a piece of non-primary legislation. Remember, for instance, a good example, the A and Others case, the Belmarsh case. There, the Lords quashed the derogating order that the government had made relating to their sort of temporary opt-out from part of Article 5. Very important to note here as well that if a court quashes a decision, it is really only doing that. It is certainly not substituting its preferred decision for that of the decision maker that has now been declared unlawful. Basically, the court is quashing the original decision, invalidating that, and then sending the issue back to the decision maker to be made again, hopefully this time in an entirely lawful way. Okay. Second order is a mandatory order. This is an order requiring a public body to do something. For instance, compelling it to carry out a public duty properly that has been imposed on it. Okay? Clearly, there will be a view that it didn't carry this out properly in the first place. Now it must do so. A prohibitory order prevents a public body from continuing to act unlawfully if that is the case. Now, these middle two remedies are not, they're rather different in nature. They are also discretionary, but of course they're not exclusive to public law. They can be applied for along with one of the first 3 orders. So, for instance, a declaration is a statement of the correct legal position by the court. Sometimes this is really what the claimant is after. This may be applied for so that a legal principle can be established on a particular point. This is going to be more of a point of principle, of course. You know what an injunction does, no doubt you've studied that in other areas of the course. Basically, a party can be ordered to stop doing something. Now, I put damages separately because this can sometimes be awarded, but this is really quite rare in public law. It's only likely to be ordered when there is some kind of private law element to the claim as well. Okay. Last slide, this is really just a brief rundown on the key points that you need to cover in the preliminary section of the a JR problem question. So, similar broad approach to what we do in human rights, but these are specific to JR. And of course, some of these I covered last week. So the first issue is whether the decision being challenged is a public law decision. Is it governmental in nature? This is the amenability question. Following on from that, we are asking whether procedural exclusivity applies. If the matter is a pure public law matter, then certainly to be safe, JR procedure should be the process used. Thirdly, really what we've mainly dealt with today, does the applicant have sufficient interest in the subject matter of the application made? So this is the core issue of standing. Of course, think about on the facts of the problem question whether there are pressure groups or associations involved as well. Fourthly, is the claimant within the strict time limits that apply in JR cases? Remember, 3 months as an absolute maximum. And fifthly, this won't apply in all problem questions, but always be on the lookout for ouster clauses. Do any of these need to be considered? How will the court react to them? Okay, so that's a brief rundown of the key preliminary matters you should bear in mind at the beginning of each JR problem question. Okay, I'm going to leave things at that stage. That's just a note of the next lecture. Thank you.